Welcome to the show, everyone. Today is Tuesday, March 24th, 2026, and we are so glad you are here with us.
Yeah, thanks for tuning in. And before we jump into things today, we really want to just say a massive thank you to all of you.
Oh, totally. The response to our last deep dive, the one called New PR Rule in Canada, millions could be affected. It was just incredible.
It really was. The engagement was off the charts. And, well, we want to implore you to keep that up. Comment, like, and share this deep dive so others can benefit from the discussions. It helps us out a lot.
Exactly. Our mission here is to dive deep into crucial community issues and happenings around the world. We take the source material and just unpack it to bring you the facts without all the overwhelm.
Right, and we really rely on your input for that. Like last time we asked you to send a message to our email about what you wanted us to discuss next regarding Canadian immigration or opportunities and other happenings.
And you definitely delivered. Our inbox was completely flooded. So, based on your suggestions, today we are taking on one of the most interesting and probably the most heated topics out there right now. We are talking about Bill C-9 Explained, the law that has Canada divided.
It is a massive topic. And hey, please send us a message with what you want us to talk about in our next deep dive. We read all of them. Also, if you want to advertise your products on the show, you can reach out by sending a detailed message to deepdive247@gmail.com.
Yes, deepdive247@gmail.com. Now, before we get into the actual mechanics of Bill C-9, which is commonly called the Combating Hate Act, I need to make our mission for today absolutely clear.
Very clear.
Right, because this bill is currently at its last vote in the House of Commons, and it contains some heavily politically charged content. So we are not taking any sides, period.
No sides at all.
We are just impartially reporting the facts from the source material. We want to convey the original ideas and arguments. We aren't endorsing any left-wing or right-wing viewpoint. We just want to give you the facts so you can make up your own mind.
Exactly. And, to really grasp why a law like this is even being pushed right now, we have to look at the broader global stage.
The global context is huge here.
It is. We are in a time of just intense global polarization. I mean, look at the current happenings between Israel, the U.S., and Iran.
Oh, absolutely. And what that war has caused regarding the oil scarcity and just the expensiveness of everything around the world right now, it's affecting everyone.
Yeah, the economic pressure is just one part of this massive pressure cooker we are all living in, driven by these Middle East conflicts, especially the war in Gaza following that October 2023 Hamas attack. There is a worldwide surge in both anti-Semitic and anti-Muslim rhetoric.
Yeah, it's everywhere.
And then you add in rising terror threats, right? Like the ISIS-K mass casualty attacks we saw in Russia and Iran back in 2024. Governments are under immense pressure from their citizens to just do something.
Okay, let's unpack this. Because to understand why Canada specifically is so divided over this, we first need to look at exactly what Bill C-9 proposes to change in the criminal code.
Right, it's not just a minor tweak.
No, it's a whole package deal. It creates a brand new standalone hate crime offense for any federal offense that's motivated by hatred based on race, religion, gender, things like that.
And the penalties for this are severe. They can scale all the way up to life in prison.
Wait, life in prison?
Yeah, if the underlying offense tops out at life, the hate motivation can push the penalty all the way to the maximum. And on top of that, it creates these new intimidation and obstruction offenses.
Right, the ones aimed at keeping people safe while accessing places of worship or schools, daycares, community centers.
Exactly. But I think the standalone charge is the biggest shift.
Okay, so help me out here. I kind of view this standalone hate crime like a video game multiplier. You take a baseline crime, you add the hate multiplier, and the penalty goes way up. But in a real courtroom, what is the practical difference between charging this as standalone crime from the start versus just letting a judge consider hate as an aggravating factor when they're handing down the sentence?
That is the crucial legal distinction, because making it a standalone charge shifts everything. Right now, hate is usually just a post-trial sentencing factor.
So after you're already found guilty of assault or whatever?
Right. The judge says, I think this was motivated by hate, so you get a longer sentence. But Bill C-9 makes it a central charge right from the beginning. That means it can be negotiated in plea deals, and defense lawyers have to contest it directly during the trial.
Oh, I see. So it becomes part of the actual trial debate.
Exactly. Proponents say society needs to clearly denounce the hate itself, not just the physical act. But critics are really worried because this drastically widens police discretion.
How so?
Well, proving a specific action is one thing, but proving someone's internal motivation is often inferred. They worry that inferring motivation can sometimes track with underlying biases in the justice system.
Wow, okay. Taking these new legal definitions out of the courtroom, how will they actually affect, everyday life on the streets of your community?
That's where it gets really complicated.
Right, let's look at those new access offenses. The bill targets behavior intended to provoke fear or intentionally block lawful access to specific locations.
And supporters argue this is absolutely necessary. There's been a lot of documented harassment outside synagogues and mosques, and police warn that this kind of behavior frequently escalates into actual violence.
Yeah, no one wants to feel terrified dropping their kid off at daycare.
Exactly. Here is the opponent's stance. Civil liberties groups, like the Canadian Civil Liberties Association and various labor coalitions, they argue that intimidation is a really elastic concept.
Elastic meaning it can be stretched to fit whatever the police want it to fit.
Precisely. They warn that tens of thousands of locations, which often double as workplaces, could suddenly become no protest zones. They say it violates fundamental collective bargaining and protest rights.
So let me put you in a scenario. If I am a teacher legally striking outside my school, or maybe I'm protesting a political issue near a community center, am I suddenly committing a federal intimidation offense?
What's fascinating here is how the law tries to handle that. There is an exception written in. It says you aren't guilty just for being near a covered place to communicate information.
Okay, so a picket line would technically be covered by that exception.
Technically, yes. But civil liberties groups stress that the mere fear of arrest causes a chilling effect. Even if the charges are dropped later, just the threat of being arrested and going through the legal system is enough to stop lawful protest.
That makes total sense. And it isn't just about where you protest, right? It's about what you hold up while you're there. Which leads us to the new hate propaganda offense regarding symbols.
Yeah, the symbol display offense.
Right. Under Bill C-9, it becomes a crime to willfully promote hatred by publicly displaying specific Nazi symbols, like the swastika or SS bolts, or symbols principally associated with listed terrorist entities.
Now, there is a legitimate purpose defense built in for things like journalism, education, or art. So a history teacher showing a flag in class wouldn't be arrested.
Right, but the community concerns here are loud. The International Civil Liberties Monitoring Group warns that the phrase principally associated with is incredibly vague.
It is very broad language.
Here's where it gets really interesting. If I'm at a massive rally,
right,
like thousands of people, and someone next to me unfurls a flag that the police suddenly deem a terror symbol, could I get swept up in that?
That is exactly the fear. If we look at the international trends, democratic nations are really trying to blunt extremist propaganda. CSIS, the Canadian Security Intelligence Service, has warned about Daesh-inspired extremism here.
So the government's trying to cut off that propaganda.
Right. But applying this on the street during a chaotic protest, it risks importing highly contested geopolitical conflicts directly into everyday Canadian policing. It leaves communities very uncertain about what is actually legal.
Yeah, that uncertainty is terrifying. But while the symbol debate is about visual expression, the most explosive controversy in Bill C-9 actually centers on spoken and written faith.
This is a huge shift.
It really is. The bill repeals the long-standing good faith religious opinion or text defense for the willful promotion of hatred.
Basically, supporters say scripture shouldn't be a shield. You shouldn't be able to preach hate and then hide behind a religious text.
But opponents are arguing this removes a vital safeguard. They say it risks criminalizing sincere theological views, and it forces secular courts to police spiritual doctrine. So, what does this all mean for religious scholars? Is quoting a controversial religious text suddenly going to land your local religious leader in court?
The government knew this would be controversial, so they tried to create a balance. They kept the requirement that the Attorney General has to actually consent to prosecute any hate propaganda charge.
Wait, really? So a local cop can't just charge someone on the spot for a sermon?
Exactly.
Yeah.
The Attorney General has to sign off, which acts as a filter. They also added language clarifying that speech isn't criminal solely because it offends or hurts. They defined hatred very strictly as an intense emotion of vilification.
Okay, so being offensive isn't a crime, but vilification is.
Right. But even with those guardrails, minority faiths still feel incredibly vulnerable to politicized prosecutions.
And if someone does end up on the wrong side of these new laws, the consequences are just massive. They don't stop at a fine or jail time. They tap into massive state surveillance powers and even immigration status.
This is where it gets very real for a lot of people.
Yeah, under Section 36 of the Immigration and Refugee Protection Act, or IRPA, a permanent resident or foreign national convicted of an offense with a maximum 10-year penalty can actually face deportation for serious criminality.
And because these new offenses can carry such high maximum penalties, that threshold is crossed.
So if you are a permanent resident exercising your right to protest, and a police officer decides your chant crossed the line into intimidation, you're not just facing a criminal charge, you could lose your life in Canada.
Yes, deportation is a very real collateral consequence here, and it goes further into surveillance. The new intimidation offense is actually added to the criminal code's wiretap list and the DNA regime.
Wait, wiretaps for an intimidation charge?
Yeah. If we connect this to the bigger picture, you can see why Muslim and other racialized communities view these powers with such deep suspicion. A Senate report on Islamophobia explicitly warned that past security tools and counter-extremism efforts disproportionately targeted Muslims.
Oh, wow.
Yeah, it created this deep distrust of law enforcement. Advocates are constantly asking, do these laws actually improve public safety? Or does widening police discretion just stigmatize marginalized communities even further?
That is the million-dollar question. Because comparing how other democratic nations address this balance between national security and free expression, it's always a tightrope.
It really is. The opposition on this Bill C-9 has been hammering that exact point. They argue that the government is overreaching and that these sweeping powers are ripe for abuse.
Okay, so let's briefly recap this journey we've been on today. Bill C-9 is trying to address very real, documented fears of harassment at places of worship and schools.
Nobody denies that the harassment is happening.
Right. But it uses the absolute heaviest tools the state has. We're talking standalone criminal charges, wiretaps, DNA collection, and severe immigration consequences. And critics fear that peaceful protesters and religious minorities are going to get caught in the crossfire.
And before we go, I want to leave you with a final thought to ponder on your own. Given that Bill C-9 explicitly ties physical access intimidation to digital surveillance tools like wiretaps, what happens when the definition of a community gathering place evolves?
Oh, that's an interesting point.
Think about it. If a religious or cultural community meets entirely in virtual reality or digital spaces, how will these physical world intimidation laws be applied to avatars and online swarms?
Wow, that is definitely something to think about. The law is going to have a hard time keeping up with that.
Exactly.
Well, thank you so much for joining us on this deep dive. We really appreciate you spending your time with us.
Yeah, thank you. And remember to email deepdive247@gmail.com with ideas for future topics or if you want to advertise on the show.
And as always, remember, we do not take political sides here. We just want to empower you with the facts so you can make up your own mind. Have a great day, everyone.